Let's talk accountability now, shall we?
Right. And of course, at this COVID time, one of the big issues is, government funding for, safety nets, looking at how to provide the medical equipment and facilities that are needed to deal with the pandemic. And one of the realities is that government does not have the fiscal space or the money to do this because of debt. And one of the big impacts or one of the big debt decisions that was taken was around the standard gauge railway. And this is a Chinese loan. And government has borrowed heavily to finance the SGR. So one borrowed from China, also borrowed, from the commercial markets to finance the SGR and the associated. So what the situation we're in is that there was a recent court ruling where the Court of Appeal determined that the procurement process around the SGR was illegal, did not comply with the law. And we then have a country where we are paying heavily to repay for contracts that were overpriced, single-sourced, and the likes. So Kenya, we find ourselves in a situation where, despite the constitutional safeguards around debt acquisition, around public finance, government has then made decisions to finance the standard gauge railway that has put us heavily in debt, and the Auditor General report and the court, the Court of Appeal decisions indicate that there was corruption here. So the big question for us, I think, is twofold. Number one, this isn't the first time we're getting into debt around large infrastructure projects. Moi had his golden bag, white elephant, big corruption scandal. Kibaki had his Anglo leasing. Again, another white elephants, big corruption scandal. Now, Uhuru has the SGR. And this, again, is a huge corruption scandal. And we are then wondering where to from here. So the thing with debt is that we tend to think, well, that's government borrowing. This is a big scheme. It's about the Chinese. But it's coming to bear on us when government can't invest in basic healthcare.
In other things.
When you saw last year, there was a big standoff between county governments and the national government over the sharing of national revenue. And the president saying, we don't have the money. Is it really acceptable for us to say we don't have the money when we know this money is going to pay loans for contracts that have now been found to be illegal, to be faulty?
So the Court of Appeal decision found fault with the contracting or with the management of the project?
The contracting.
It's a contracting.
It's the contracting.
How we got into this particular contract with the Chinese government and the associated companies
exactly
is where the questions are.
Exactly.
And what are these questions?
Well, those are the questions that we hope Sheila Masinde will unravel for us. But they are around the procurement process. Yeah.
Eric, with the contracting, it's not even who we got. I mean, that may be part of the questions that you're going to ask. But in the fine details of what we get, how we secure it, how we pay it. Our problem is always in the contracting. This issue of Kenya Airways, you'll find the issue of contracting comes in again. Whether it's for the fuel, whether it's for the buying of the planes, contracting will come in. It's always in the contracting.
It's in the detail of the
contracting. That's where we lose out, because you ask yourself, how on earth did we end up in this setup? How?
Yeah, so this was in the procurement, and I think Sheila Masinde will highlight what part of the procurement process. And there are several parts. One, okay, you draw up a contract, you identify the providers, you then also there were processes that took place around this because there were land acquisitions. So, contracting usually it happens at many levels, and so we'll get the technical details around that. But the principle for me, and the bigger question is, you know, what do we do about this? Because we tend to reveal these scandals. We all
it's
get
already done and dusted.
You know, we all get very, you know, very upset
Emotional
about
and
it.
upset.
But that's about it.
And then business as usual. And so presidents have calculated and said, look, all they'll do is talk. At the end of the day, big deal. Mutadu.
As we introduce Sheila Masinde, who's the Executive Director of Transparency International, Kenya, Wanjiru, how do we tie in this conversation to sovereignty? I mean, where is our sovereignty now coming to question?
It's a very painful issue. And it's not only Kenya that's facing this. And you know, there's this Okoa Mombasa coalition that has already started this conversation. Sovereignty is around the contract. Because the contract through which the Kenya government got into this agreement with the Chinese government has a clause that states that arbitration on this contract will be based on Chinese law and not in line with Kenyan law, and actually says that this issue of sovereignty does not come to apply in the arbitration process.
You cannot argue sovereignty.
You can't.
At any point during arbitration or any conflict.
Which means our government at some point ceded our sovereignty. The second thing is you collateralize debt. You say, yes, we're going to pay and these are the terms. And if this doesn't work out, then this is the collateral that we're offering. Now, this contract has never been made available. And Okoa Mombasa coalition has been pushing for this. Katiba Institute went to court also pushing for this contract. This contract has not been made available. Kiom Tata also. This contract has not been made available, so we do not have the fine print. And in fact, part of the conditions around this contract was not revealing the details of collateralizing. So Article 1, sovereignty of the people, has been violated. And the question we have to ask ourselves is, you know, the reality is that it's good to talk, it's good to understand, but it's not enough. When Moi violated, you know, during Goldenberg, Anglo-leasing, we did not have these strong constitutional safeguards. And we have to ask, what do we do? And sovereignty is one thing that, it's what we need to maybe borrow a leaf from Malawi, where the judges there said, we knew our life was at risk, but for democracy and of the country, we had to take this step. So I think as Kenyans, we really need to ask, are we prepared to stand for our sovereignty? And
Sheila Masinde is the Executive Director of Transparency International Kenya. Good morning, Sheila.
Hi, Eric. Good morning.
Good morning to you. Thank you very much for speaking to us this morning. Welcome to the Situation Room.
Thank you for having me this morning.
You've heard our introduction and how Wanjiru has introduced this topic, talking about the specific loans that we took from the government of China to finance the SGR project. And it brings in the issue of sovereignty. And there, you know, there have been decisions that have been made by the Court of Appeal in terms of rulings that found parts of this contracting to have been illegal, right?
Yes.
And the question we asked is, what exactly does the Court of Appeal have an issue with? Is it the details of the contract? Is it the revelation of the details of the contract? What exactly is it that the Court of Appeal found?
Well, some of the issues that have been raised in the judgment by the Court of Appeal was that the Constitution was violated, and as well as public procurement laws in the manner in which the project was secured, lack of transparency, accountability, and also there was no cost-effective evaluation of the project. And some of these things, I mean, we've been asking about them since SGR came into the picture. And another key issue raised was the fact that there was no due diligence that was conducted. There was no independent feasibility study and design of the project. No design of the project was undertaken before seeking contractors to implement the project. And had this been done, then a conflict of interest will have been noted as the China Road Company funded its own feasibility study, and then the same company is then contracted to build the SGR. And if we had done a proper due process, then would have noted that China Road was ineligible for the award of the contract because it had also been blacklisted by the World Bank following corruption in road projects in the Philippines. So there was lack of due diligence. There's also the issue, and I think Wanjiru has raised this, the issue around single sourcing of China Road companies to execute the project. And this contravened various provisions of the Constitution, Article 10 on our national values and principles of governance, and various other articles on public finance management, some of our laws on anti-corruption, the Public Officers Ethics Act, and others. And because of this, then, the court declared that the contract awarded to China Road was unconstitutional, irregular, illegal, and invalid. And then there was also the failure to undertake an environmental impact assessment before implementation of the project, because this is something that environmentalists have talked about for some time now. The SGR runs through a national park, and with irreversible and irreparable environmental impact, and this affects various other sectors, tourism, wildlife, environment, natural resources, and so on. But I think maybe just to highlight that there are many concerns that we have had on the SGR whole process, the contracting, and even now it's running. There's been a lot of questions and revelations around, transparency, and Wanjiru has said that even up to date, whatever we have, what is out in the public light in terms of the contract, have not been issued by the government. These are details that have been gotten underhand and rather behind the scenes. So we have questions about transparency in terms of, what the government has yet to come to us and tell us the details of the SGR agreements, one with the Exim Bank and also with the China Road company. There have been questions around corruption. We've seen suspected ticketing fraud scandals. There's been questions around mismanagement and inflation of costs.
Yeah.
So there are various concerns we have around the SGR.
Many issues that I hear you mention, Sheila, and they make sense because these are issues that we've had being discussed over and over and over again. But what I hear you say is to the end of the contracting. Well, there is the issue of who conducted the feasibility studies. Did we have environmental assessment studies done? All those. But specifically to the issue of procurement of the loan, has the court pronounced itself on this particular matter? On the loan itself, this is how much we've borrowed, and this is this is the collateral that we've put in place, or this is what the agreement says.
I think the court was more clear in terms of the process, procurement, the process of contracting for the China Road and company.
So Sheila, we're looking at this entire contract as being illegal? Is the illegality being applied to the entire contract or processes of?
So it's more or less the process that was used in terms of procuring the companies. That is what the court has declared as looking at our procurement laws, looking at the Constitution as unconstitutional, irregular, illegal, illegal.
Okay. So now if we're looking at the reality of this, Sheila, what then does this mean?
Well, I know that for now I've heard that the government wants to appeal. It was an appeal at the Supreme Court. But in essence, I think we really, as Kenyans, really need answers because we have questions about value for money and whether Kenyans have been able to get any value, or even if any of us will see any value accruing from that project in our lifetime, given that we have a lot of loans to pay and the profit or whatever from the railway line is little compared to what we have to pay back. So I think Kenyans really should be asking critical questions, and particularly asking that individuals who were responsible for the decisions that were made in terms of procurement of and contracting of China Road should actually be held individually culpable. But then now we know that the government intends to appeal that decision. That's what I understand as it is now. But to be honest, I feel that officials involved with the contracting should be held individually liable because they made decisions that predispose us Kenyans to economic losses of monumental proportions. As I said, we will not be able to recover any profits, at least for us who are currently existing as of now in our lifetime.
You know, Sheila, I think where we get stuck is the question of what are the options on the table? Because this issue was flagged as far back as 2014, I think. Africog invited David D. and Kerera, and I remember they were talking at Ufungamano and made statements on the SGR even before the contracting had taken place. And they raised some of the issues that the court has now come to find. And of course, government didn't listen to this caution. And, you know, they talked about the inflation, they talked about the lack of feasibility, they talked about some of those things. And they have continued to talk about it. The Auditor General also there's also an audit report on the SGR raising some of these issues. So the Auditor General had also raised concerns around this. And I don't know the extent to which those recommendations are actionable. And now we have the court. So we are sitting here thinking, Sheila, where do we go with this when there's kind of, you know, really overwhelming evidence of corruption, and all we can do is lament. What are your thoughts, Sheila?
Yeah, no, I agree with you. You know, I know this subject was raised way back. I even remember even as far as going to Parliament and asking the Parliamentary Committee on Transport questions then. But then they gave a report that gave a green light for this project. But I think in terms of way forward, one of the things perhaps we might also want to do, even if the court process continues, is even just a citizen-led audit. I know the police will be access to information, and that's been a key problem running through. Even for us, we vote twice to ask for information on this agreement between Exim Bank and the China Road Company, but this was denied. But I think one of the things we need to do perhaps is just see how we can conduct an audit led by citizens to establish all amounts, what has been expended, the items expended on, what are the goods and services that have been delivered, and just do a thorough assessment of value for money across all parameters in terms of looking at the economy, efficiency, and effectiveness of the loan that has been procured and what we have received so far in terms of services and goods that have been delivered. I think that will help us at least assess what have been the loopholes and what have been actually the areas of corruption, and try and see how then can we deal with it, whether it is legally or administratively. I think also moving forward, we also need to seek an audit of all, you know, tendering processes that are ongoing for the phases of the project that are continuing as we speak, and maybe then see how we can get legal redress as citizens. I think to some extent it might need some citizen-led processes, maybe private prosecution to some extent, for us to be able to answer for any wrongs that have been committed in the course of this project.
In terms of the individual responsibility, the officers who at every turn have enabled this process, either through, you know, omission or commission. We know some people are forced to step down, but, you know, there have been many actors along this chain, and you talked about looking at individual responsibility, maybe even going up to Parliament. What framework exists for that? You know, what is that social sanction? Are there legal measures? Are there some anchors that can be used in law?
Yeah, I mean, Kenyans, we can go to, as I said, we might now need to have to think about private prosecution and public interest litigation around this. And we've seen many cases. I mean, for instance, the cases that have gone so far to court have been cases of public interest litigation. You've talked about Mombasa and also what Okia used. That was an example of public interest litigation. I think because when you look at the wheels of justice and how long they move in this country, like currently we have some of those people, some officers from the National Land Commission and the former MD of the Kenya Railways Company who were charged in court, was it last year or the year before, but that case is still going on, and there are concerns that it will take long because of the complexities around the case. In average, our corruption cases take about 5 years to get a judgment. But that's why I'm thinking we might have to think about public interest litigation and see whether we can actually hold some of these individuals accountable.
At this stage where we are, Sheila, because, I mean, you talk about looking forward, but here we have an issue that it's, I mean, if you look at the face of it, it's a big deal. But then I also, unfortunately, hear those voices already that are saying this one is dead in the water. It has happened. There's very little that can be done about it. And so moving forward, we have to be a little bit more careful. Is that where we are with this? Is it already a done deal?
Well, of course, we have to be more careful moving forward. We know that there's another phase that have been proposed for SGR. And now there are questions, and we really need to be asking government. Now that this judgment came from the court, what next? What is the government's move? The government has also given an advisory, I mean, that's the state law office, that for instance, the Kenya Railways should cut the contract or seek an early handover from Africa Star, company which has been managing the SGR.
Right.
But then you see there's still we don't have a decision yet from government how they move forward. So I think those are the kind of questions we should now ask government, like, what exactly is the risk for this contract, given that this are the amounts owed. And of course, there are also concerns. Again, we also have to be careful because we have entered an agreement. And of course, we are internationally, looking at the international law, we have committed ourselves in terms of payment of this amount of money. So we also have to look at it, that despite the fact, this process has been termed invalid, but then you've already entered international agreements. So what does that portend? Really the government also should be coming to us and telling us, okay, this is the way forward. This is the course of action that we plan to take. But moving forward, I think in terms of how we move forward, I think this was a good judgment. It sets precedent in terms of public procurement, particularly of large-scale projects. I think it says a lot about what we need to do in terms of ensuring that with open contracting in public procurement, in all the deals that are entered to on behalf of the Kenyan people, we need to ensure that bidding processes and negotiations are very open and Kenyans understand what is happening. Because by headhunting a single entity to build a railway, it obviously did not get value for money, and we may never see the economic returns from that rail line in our lifetime. So I think we've learned a lot of lessons in terms of open contracting, and it's also for us now as citizens to be able to actively advocate for access to information and also ensure that there's public participation in all these contracts the government is entering into on our behalf. Because open contracting will reduce corruption in this kind of processes, and it will enable us as citizens to also monitor any of these contracts and any agreements that have been made, so we're also able to hold duty bearers to account. So as much as I said, there's a lot of unclarity. The government needs to come forward and tell us, okay, now this is what we plan to do as a government, given that has happened in the past. I think we need to demand of the government to give us a way forward, because they're talking about extension of the railway line to Malaba, and so already those are more costs. But where is even the money coming from? So there are many questions that we need to ask from an economic point and also from a legal standpoint.
I hear you talk about this current government, and yet the contract is what was signed during the tenure of this government. The process of actually the SGR began in the Kibaki government, and there were players in the Kibaki government who were involved in that process. This government simply took over from where they had left off.
Yes.
Now, when one says that we will force the government, when one says we will ask the government, the question that comes to mind, which government? This particular one. Because since when has this government ever responded to questions of that sort in any meaningful manner? But the fact that this matter was taken to court means that the responses were inadequate. And people were inadequate, and they were fed up of whatever it is that the government was doing. And the government seems to be very committed to continue doing exactly what it keeps doing. So apart from they've been taken to court, how else do you ensure that the government actually not just only abides by what the court goes by, but how do you ensure that such a thing doesn't happen again? Because talking about it certainly will not prevent it from happening again.
And that is why I keep emphasizing that we need to hold individuals personally liable for this. Because, yes, we know that we've seen how government has also reacted to court orders with massive impunity. And that continues to be a concern, that our government failed many times to adhere to judgments and orders coming from the courts. But that is why another avenue would be to hold individuals liable. And this would set a precedent, because we have many complaints about the conduct of public officers. You know, we have many cases of abuse of office and pilferage of funds by people holding office. But we need to hold them personally liable, such that when someone is sitting in that high office, they know that they are not going to be immune to any action should they fail to protect public resources.
Sheila,
and that is
TI ran the Red Card campaign, which was about this personal responsibility. How did that go? And what were the impediments and what are the opportunities? Because, yes, we're interested in personal responsibility. Look at the CS, look at who was the PS, look at the various points of decision making. And you might even find that maybe some of those individuals have a history. You know, every office they sit in, these kind of dubious contracts are signed. And yet these people manage to continue holding one office into the other. But what experiences did you learn from the red carding campaign? Maybe you can explain a little bit about what it was and if there is hope for us to hold individual public officers to account.
Yes. I didn't hear part of the question, but from the end, I'll just pick it up. The red campaign for us was about ensuring that people who had integrity questions were not given the green light, were not given certificates of nomination by IBC to vie in the elections. So TI Kenya, together with other society organizations under the umbrella of the National Integrity Alliance, this is a list of 20 people, having assessed various accountability reports of the Auditor General, Parliament, EFCC, and other court reports, and came up with a list of 20 people who we said should not be given clearance to vie for office. Unfortunately, the vetting processes did not take place as designed by law in 2017, and most of these people were given clearance to vie for office. Now, the upside of it is that if you look at half of that list as we speak now, most of them have been caught up in other corruption cases, particularly the ones who ended up being given the green light to vie for office and were elected. So, of course, we have a difficulty in Kenya, a challenge, a big challenge, where it has been a custom that despite people having been accused or suspected of corruption, you'll find that they will get reprieve within their communities or within their constituencies. So some of these people got elected, but unfortunately were caught up in other new corruption cases. So I think it's a practice we also have to build this country, where we also inform citizens of, and I think a lot of them are seeing that now. You've seen what has happened in Nairobi. You saw what happened in Kiambu. The governors of those counties were actually among those listed in the red card list. And right now, you've seen that they're facing cases in court, and the Kiambu governor went ahead to be impeached.
Can I ask you a direct question, Sheila?
Yes.
With reference to holding individuals accountable, does Transparency International have a list of individuals who they feel should be investigated personally?
Well, we haven't built a list yet, but what we have done so far is we believe in evidence. Currently, one of the things that we have been doing is looking and analyzing the reports from concluded cases of corruption in the court. And we have a data where we are putting all this information, including the people who have accused and found guilty. We hope to be able to provide this data as a point of evidence, the point when we need to go to the next elections, or even now, as we're continuing to appoint people to public office, because this person has actually gone through a process. They were suspected of action. They've gone through, or they're going to be in court. So they should not, during the vetting processes, they should not be given clearance to move on to another public office or even to seek elective office.
Now, Sheila, when I hear when you talk about now the processes, there has been a lot of corruption allegations and suspicion of serious fraud happening, even going into the land. The officers of the National Land Commission and Kenya Railways Company are under investigation by the EACC over procurement of land for this particular project. Then also you've raised the issue that has been taken even to the Court of Appeal in terms of how the contracts were awarded to China Road for doing this project, how the contracts have also been awarded to the company that is managing the railway services for now, how much we are paying them, and that entire process. Then there's the issue of how we procured the loans and the details of that loans, because that also brings in the issue of our sovereignty in terms of the details of the contract. That matter still hangs somewhere in the air. It's discussed at some point, and then it doesn't even get solved. As in, what is it that we have committed ourselves to in procuring $3 billion for the construction of railway from Mombasa to Nairobi, and a further $1.5 billion from Nairobi to Naivasha? Sheila, are you there?
Yes, Eric. Sorry, just repeat the last question.
Yes. So my question is with regards to borrowing and the details of the loans that we've taken.
Yeah.
Do we have any semblance of clarity on what exactly we've put ourselves into?
There's really no clarity because we don't have the details of the contract. And as I said, what is out there, and even the court expanded it from in its judgment, because it was said that it was not gotten in the right way. So we don't have the details of the contract to be able to scrutinize it. And it's really one of the things that we've also been lobbying for in terms of in terms of loan, our loan agreement, what information is out there in the public. And really, when you look at most of the debt that's out secured in this country, there's really little transparency in terms of what we are getting financed from out there, what that money is being used for, how it has been utilized and expended, and so on. So it really just emphasizes the point that in terms of financial transparency, particularly in terms of debt acquisition and use and retirement, there's really little information that we have, and it's something that we need to change in this country to enhance the kind of information that we get, so that all people, Kenyans, are able to know what is being borrowed for their benefit and subjected to more scrutiny and hold government accountable for projects that are being financed by these monies that are being acquired very expensively from abroad.
Has there been any attempt at getting the details of this particular loan?
For the SGR loan, at least from our side as TI, we wrote twice. We wrote twice in 2015 to the then permanent secretary for transport and infrastructure, requesting that the documents relating to, one, the procurement of China Road and this company to carry out the first phase of the project, and also the grant agreement with Exim Bank regarding the financing, be given to us so that we're able to assess the integrity of the process. However, this information was denied, despite the fact that, the first time, actually, we didn't get any information, and we had to write a second time after about a month. And when the letter came back, we said that this information cannot be given to the public. Of course, now we understand, because when you see whatever information has been leaked in terms of the details of the contract, it imagines that these details are not supposed to be provided to the public without the approval of the China Bridge. That's how I understand it.
Which brings me
So
now to the
perhaps that's
question of
Yeah.
we, the people of Kenya, in exercise of our sovereignty, how can we demand access to this information? What does the law give us? What does the constitution give us in terms of tools that we can use?
Of course, any Kenyan can request for information, as we did, by first writing a letter, and there are certain timelines which are then provided under the Access to Information Act. Of course, we're waiting for regulations which are currently being developed by the Commission on Administrative Justice to be able to guide the full implementation of that law. But even as we speak now, just because this is provided for under the Constitution, everyone has a constitutional right to access any information held by the state. So, ideally,
but you have tried.
It's
as
not
Kenyans,
given.
and you haven't
It
got-
doesn't come. So where
Yes.
where do we stand? Even because it sounds to me now that this is, in terms of what can happen, it's a lesson for the future.
Yes.
It doesn't sound like there's something that's going to be done, even with this case. It doesn't sound like suddenly this information that's being sought will be provided. It doesn't seem that the tenets of this contract will be repealed. It doesn't sound like going forward or going to say it's going to be an overturn of this contract. Those three things don't seem like they'll be any part of any kind of reality. So it seems like this whole process is going to be a lesson for the future, as opposed to something tangible being done.
In fact, Wachira Maina put it very well in the Africa report, where he said, when you're in a state of capture, the government repurposes official institutions and processes for private ends.
Yep.
And you therefore find yourself operating within formal government structures, but decisions are being taken outside
of the structure.
And that is where we are. We have a constitution, but things are happening despite. And in fact, the reality is we haven't yet confronted our reality because it's painful. You know, when somebody violates your sovereignty, when your constitution is violated, at that point,
And you allow it.
And yes, at that point, your action is,
over.
it has to be actually the only recourse we have is non-violent action. It's to demonstrate.
Constantly.
Then you
But
go
does
back,
the government
demonstrate to, I don't know, like
Actually-
boycotts. That is actually the only.
Do our own Tahrir Square to Huru Park.
That is the
Over
only
and over and
recourse.
over
It's
again.
just that we are afraid. Call it what
But
it
Sheila,
is.
does the government
Yes.
have any leeway at all to sign such a contract where it says that its details cannot be shared with the public?
Not under our constitution.
Not-
Absolutely not. Our constitution is very clear in terms of the public finance, management
Yep.
and access to information. So no, this was something that is certainly done outside our constitution and violated our constitutional rights as Kenyans.
Can I add another point? Because I'm looking at a related article from the BBC, and Sheila, you mentioned this issue of value for money. I'm not even sure we need to do an audit, because this is an article from 2017, actually, that is questioning the value for money and saying that this, already at that point, at $5.6 million per kilometer for the track alone, Kenyans' line costs close to 3 times the international standard and 4 times the original estimate. So whatever was estimated in the original Kibaki agreement was a quarter,
Quadrupled.
was a quarter of the cost that was
That ended up.
Yes. A second point. When last year the president went to China to negotiate again, can we get the Naivasha, now we want to go all the way to Malaba, because we still don't have a railway that gives us the solution we need, which is the coast to the border. We don't. We are less than halfway. China refused with the loan. And so what did government say? They said, we'll rehabilitate the existing line. Now, the World Bank had recommended to Kenya in 2014
For us to
that they
rehabilitate
rehabilitate this line,
existing
because they
line.
said, number one, you do not have the volumes to manage,
Justify.
to pay back the loan that the
That you're
one
seeking.
quarter, one quarter loan, not the quadrupled. So at the original cost, they were saying, look, first build up your business to be able to pay off, because you borrow, you have to pay.
Yep.
So apart from corruption, Sheila, There are also questions around sustainability, and the Constitution actually has a provision about, it has very strict principles in terms of sustainability of development. So it's possible that, you know, we could go to court to argue about, you know, those issues of sustainability, but it brings us back to the point that this government doesn't really care about court rulings. and you know, so even if we go to court,
we come back on that
change
particular
will only
issue
come
of-
when
so
citizens are felt.
What even was taken to
And
court
felt.
in terms of the details of this contract, and Sheila, you've alluded to that, was expunged because it was said, look, you're bringing me rumors before court. How did you acquire this information? Well, it's not the right way of acquiring information. We need to have a way of knowing what exactly does this contract of our loan say. And the question is, how can we get that information
No, it wasn't
as we go into
expunged
it?
because the court has already ruled based on what was available in the public domain. There are details of the contract that are still not known, but there was sufficient because obviously government has to, there are processes that have to go on. So no, the court has made a ruling despite withholding of
But
information.
not on the loan.
Not on the loan.
It's
eh?
on the contracting,
Okay.
right? It's on the contract and everything else.